Welcome to the FCPA training series from Corporate Compliance Insights featuring CCI founder Maurice Gilbert and Tom Fox of Tom Fox Law. Tom has practiced law for 25 years and is now assisting companies with FCPA compliance, risk management, and international transactions. Tom writes and speaks around the world on a variety of topics ranging from FCPA compliance, indemnities, and other forms of risk management. The videos in this series provide an introduction to FCPA compliance for legal, compliance, and operations personnel. Please note, the information should not be considered all-inclusive, and we encourage viewers to seek professional advice prior to implementing any compliance program. So let's get started.
Hi, I'm Maurice Gilbert with Corporate Compliance Insights, and joining me in the studio today is Tom Fox of Tom Fox Law. Today we'll be discussing enforcement actions under the FCPA. We'll be discussing in particular case studies, the good and the bad. So, Tom, can you give us an illustration of a case study that represents a good enforcement action?
Certainly. In April of 2011, Morgan Stanley actually received a declination to prosecute, which means that the Department of Justice evaluated the facts, evaluated the case, and decided that even though they could have brought an enforcement action, they didn't. This has been one of the best lessons for compliance practitioners to learn from to determine what should go into their compliance program. Morgan Stanley was credited with really having a gold standard compliance program. Specifically, they had an employee who brought to them a transaction which the company determined would violate the FCPA, so the company declined to do so. But the individual employee went ahead and did the deal. This was in the face of receiving annual training on the FCPA. This was in the face of receiving an annual certification that he was not in conflict with any Morgan Stanley policies or procedures, or indeed even their code of conduct. This was in the face of receiving at least 5 compliance reminders for 7 years, or 35 total compliance reminders that he needed to conduct business not only ethically, but under the Morgan Stanley policies and procedures. Morgan Stanley, through their own internal transaction monitoring and oversight system, was able to determine that this transaction had gone forward. They self-disclosed this to the Department of Justice. And the Department of Justice, although they prosecuted the individual, who was indeed a high-level Morgan Stanley employee and managing director, the government did not prosecute Morgan Stanley. This is an excellent case study for the compliance practitioner who wants to understand what the government expects of a company in its compliance program.
All right then, I'm sure there's, in the alternative, a bad illustration. Could you give us an example of that, please?
Unfortunately, I can, and we've had a very recent one. In June of this year, Total was fined $398 million for paying $61 million in bribes to an Iranian government official to obtain the rights to certain gas fields in Iran. If it was one thing that came out clearly in the enforcement action, it was simply that Total did not get it. They did not understand their obligations. They did not understand the compliance program they needed to put in place. They did not have a program for evaluating any third-party consultants. They did not have any internal controls for double-checking or determining where their monies were being paid for. They did not have any policies and procedures regarding payment of bribes to governmental officials. They had a complete failure and in all aspects of having any sort of compliance program. This was coupled with their conduct, which included not self-reporting. The U.S. government found out about this through other means. And indeed, through most of the enforcement action, Total denied that they had done anything wrong. This was in the face of having wired some of the money through the U.S. banking system, so there was clear U.S. jurisdiction. The Total enforcement action really stands in stark contrast to the Morgan Stanley declination because it really points out all of the things that a company can either do wrong or they certainly should not do in an enforcement action.
Tom, thanks for joining us, and we welcome you back for the next in our FCPA video series. Thanks for joining us today, and remember, before implementation of your own FCPA compliance program, you may wish to seek professional advice. Also, as a reminder, please visit us online at corporatecomplianceinsights.com.